And he took that loaded firearm, he put his finger on a trigger, and a bullet from that firearm ended up in the middle of Cindy's face.
And you shot 31 times. That was a brutal execution.
You are now dead and rotting and repulsive to me.
I have not 1 ounce of remorse for Theresanne's death.
On November 11, 2009, 30-year-old Theresanne Lynch, a National Guard staff sergeant and mother, was abducted from a parking lot in Des Moines, Iowa, by her estranged husband, Randall Moore. Despite having secured a restraining order just a month prior, Theresanne was forcibly taken back to her apartment, where Moore assaulted her and then shot her to death. When police responded to the scene, Officer Todd Rowland was also shot and wounded by Moore. He was arrested at the scene and later charged with first-degree murder, kidnapping, sexual abuse, and attempted murder of a police officer. At trial, Moore was convicted. During sentencing, Theresanne's mother, Sheila Lynch, addressed the court through tears, describing Moore's act as hateful and despicable.
What you did to my daughter, Theresanne Marie Lynch, was evil, hateful, and despicable. You are now dead and rotting and repulsive to me.
During sentencing, Moore gave an unapologetic 11-minute statement where he openly declared that he had no remorse for killing Theresanne.
And I'll tell you point blank, I have not 1 ounce of remorse for Theresanne's death. It could have all been prevented. All you had to do is let me see my kid. Now you're never going to see her again.
He blamed her family for keeping him away from their son and went so far as to say others in similar situations should experience the same.
I just can't believe what I've heard, but I am really glad you had your right of elocution and you could say everything that you said, because if anybody didn't know what a piece of work you were before you start talking, they know it now. And it's been said before, and it can't be said enough. You're cowards. You truly are cowards. You prey on women. They give you their love. They give you their trust, and you betray that. You betray it by physically and or mentally abusing these women. And they stay with you. And you guys just can't understand why they leave such wonderful men like you. I've been doing this 31 years. I've never, ever seen anybody like you. And I hope, really, I never ever see anybody like you again. The court doesn't allow me to punish you any more than I'm doing now. If I could, I would.
Judge Joel Novak condemned Moore as evil and a coward, expressing frustration that the law didn't allow him to impose a harsher sentence. He handed down 3 consecutive life sentences plus 25 years. In the aftermath of her daughter's murder, Lynch began advocating for legislation that would mandate GPS monitoring for violent offenders under restraining orders, hoping such changes could prevent future tragedies. In November 2010, 49-year-old Anne McSween was found brutally murdered behind Mario's Lakeway Lounge in Mentor-on-the-Lake, Ohio, where she worked as a bartender. Her clothes were removed and her purse and phone were missing. The investigation led to 26-year-old Joseph L. Thomas of Perry Township. Witnesses reported seeing him at the bar that night and claimed he had approached McSween, but Thomas denied any interaction with her. In 2011, he was arrested and charged with aggravated murder, kidnapping, rape, aggravated robbery, and tampering with evidence. During his 2012 trial, prosecutors introduced several weapons belonging to him, although none were definitively identified as the murder weapon. Thomas was found guilty and sentenced to death, with an additional 33 years for the other offenses.
It's like seeing what she went through. Everything that they described that she went through was going through my head. Why could he do such, who could do it? I think he's a very weak person, and for what he did, it shows that he's weak, he's got no backbone, and he showed no more remorse in there. I didn't see no remorse, none.
In 2017, the Ohio Supreme Court overturned his death sentence, ruling that the inclusion of the weapons as evidence was prejudicial. A retrial was ordered and held in 2019. Despite the removal of the contested evidence, Thomas was again found guilty on all counts. This time, he was sentenced to life in prison without the possibility of parole, along with 36 additional years for the remaining charges. In May 1999, 18-year-old Hannah Hill vanished from her home in Akron, Ohio. Nearly a week later, her body was discovered. The autopsy revealed that she had been physically abused and strangled. Not far from where she was found, investigators made a critical discovery. Hannah's clothes and personal belongings were inside a garbage bag outside the apartment of Denny Ross, a man she had recently been in contact with. This evidence led to Ross's arrest, and he was soon charged with her murder.
In that garbage bag, ladies and gentlemen, was Hannah Hill's belongings. They were her clothes, which was her shirt, her bra, her panties, her socks, her shoes, and her purse.
Ross went to trial in 2000, but the proceedings were derailed by juror misconduct, resulting in a mistrial. For more than a decade, the case lingered without resolution. In 2012, Ross was retried. The jury heard compelling testimony and reviewed the forensic evidence linking him to Hannah's death. This time, Ross was found guilty of murder, felonious assault, tampering with evidence, and abuse of a corpse. He was sentenced to life in prison with the possibility of parole after 19 years. In April 2022, 23-year-old Emily Rogers was reported missing from her Milwaukee home. After days of searching, her body was found in a wooded area in St. Francis. The investigation soon focused on her ex-boyfriend and the father of her daughter, 38-year-old Nicholas Matson. Witnesses later testified that Matson admitted to killing Emily by strangling her and enlisted a friend to help hide her body. Despite his claims of innocence and bizarre assertions, including that he and a friend had disposed of a doll, evidence and testimony pointed clearly to his involvement. In March 2025, a jury convicted Matson of first-degree reckless homicide and hiding a corpse. On April 17, 2025, during sentencing, Emily's grieving parents spoke emotionally in court. Her mother described the lasting pain and loss, while her father expressed the hope that Matson would be haunted by what he did.
I hope you never see freedom again.
I don't believe justice will ever be served, but this is the closest we can get.
My granddaughter will know what you did to her mother. You won't have to live with the rest of your life knowing what you did, and I hope you're haunted day and night about it.
Matson apologized but maintained his innocence.
My little girl suffered so horrendously.
Sorry for what my family has seen and gone through. I'm sorry for what they've seen and gone through. But man, I gotta take this. Wait to see what happens on the appeal.
The judge called Matson's courtroom behavior shocking and dishonest, criticizing his repeated lies during the trial.
It was at points shocking to watch, and yet you did it with panache. You did it with just letting it roll off your tongue from one lie to the next.
Matson was sentenced to 45 years in prison, followed by 25 years of extended supervision. For Emily's family, the sentence marked a painful but necessary step toward justice. On March 9, 2016, a deadly confrontation unfolded at an apartment on Atilia Street SE in Grand Rapids, Michigan. Robert Bruce Lowe Hallman had been asked to leave the residence earlier that day due to causing disturbances. Instead of walking away, he returned armed with a weapon. He entered the apartment and opened fire. 26-year-old Stroy Pitman was struck, killing him on the spot. The act was swift and brutal, described by prosecutors as a calculated execution. Pitman's death marked the city's first homicide of the year. Following an investigation, Hallman was arrested and charged with first-degree murder, being a felon in possession of a firearm, and felony firearm possession. In October 2016, a jury found him guilty on all counts. During sentencing the following month, Pitman's mother, through tears, addressed the courtroom, expressing sorrow, anger, and the deep void left by her son's death.
I got so much anger and hurt inside of me. You just don't know what you took away. I wish you had known my son, or got to know my son, before you pulled the trigger. But I don't feel sorry for you. Whatever you get, you deserve it. What I feel sorry for is your family, your children. And right now, my heart won't let me forgive you. Maybe someday, but not today. And I wish you all the best.
Though unable to forgive Hallman that day, she held on to the hope that one day she might.
I would like to say that I'm truly sorry for their loss and that I did not commit this crime, and I ask that you be lenient with sentencing because I have a family.
They were tending to themselves. They asked you to leave because you had caused some problems. You went outside, and instead of just leaving, you decided to pick up an assault rifle and come back in that apartment, and you shot 31 times, and you hit the victim in this matter 19 times. That is absolutely outrageous, sir. That was a brutal execution. You, sir, are clearly a danger to society. Shot at buildings or individuals with such a rifle. There's just no excuse or justification, sir. You are a danger. I don't think that you should ever be allowed out.
Judge Mark Trusock harshly criticized Hallman's actions, calling the killing a brutal execution and deeming him a continuing threat to society. Hallman was sentenced to life in prison without the possibility of parole. In March 2022, a domestic dispute turned deadly inside a Wyoming-Michigan apartment when Sakina Mohammed shot and killed her ex-boyfriend, Quan Winston. After the shooting, she fled the scene with their daughter, prompting an immediate search by authorities. She was arrested the following day. Mohammed later claimed the shooting was an act of self-defense, alleging Winston had a history of abuse. However, neighbors and witnesses described a volatile relationship where Mohammed was frequently the aggressor. Despite an active protective order, the couple continued living together, and inconsistencies in Mohammed's statements raised further doubt about her defense. In November 2023, a Kent County jury found Mohammed guilty of first-degree murder and felony firearm possession.
Ms. Warnowski, on behalf of your client, please.
Just very briefly, Your Honor. Ms. Mohammed accepts the jury verdict, however, she does respectfully disagree with it, so I would anticipate an appeal would be filed. Due to that, I would just like to express my condolences to Quan's family. It's a very tragic situation that we're here on today. I believe Ms. Mohammed does have 155 days jail credit as it relates to the felony firearms charge, so I would ask the court to assess that jail credit to her. I would also ask the court to consider reducing some of the fines and costs that are mentioned in the PSI report due to Ms. Mohammed's incarceration, and this would pose a financial burden that I don't believe she would be likely to pay. Thank you.
Thank you. Ms. Mohammed, is there anything you would like to say?
I just want to say sorry to my daughter. That's it.
All right. Fair enough. Thank you.
During her sentencing in January 2024, she spoke only briefly, expressing regret with the words, "I just want to say sorry to my daughter." The court also heard from Winston's mother, who gave a heartfelt impact statement describing the pain of losing her son. Judge Paul Denenfeld sentenced Mohammed to life in prison without the possibility of parole. On December 2nd, 2019, a violent confrontation unfolded at the Wash and Dry Laundromat in Maple Heights, Ohio. Carl Sanders, 31, began assaulting several women inside the facility. David Brown, a 73-year-old Vietnam War veteran and laundromat employee, stepped in to protect the women. During the altercation, Sanders pulled a firearm and shot Brown, killing him at the scene. Sanders fled, but police apprehended him later that morning. In court, Sanders was formally charged with aggravated murder, felonious assault, and having weapons under disability.
On behalf of Mr. Sanders, we would request counsel be assigned. We would request a reasonable bond.
Thank you, Ms. Bush. Mr. Sanders, do you have the money to hire a lawyer?
No, Your Honor.
Okay, the court will assign counsel to represent you in this matter. The court will assign attorney James McDonald to represent you with regard to bond on behalf of the state.
Thank you, Your Honor. The state, based on the nature of the offenses, the state would ask the court to continue the bond at $1 million. Thank you.
Okay, thank you. Mr. Sanders, your bond is set at $1 million. That is a cash surety property bond, and your case will be presented to the grand jury.
Okay, another Joe case. Samuel Peterson, 646-654.
Given the severity of the crime, the judge set the bond at $1 million. Initially pleading not guilty, Sanders later changed his plea to guilty. On June 10, 2021, he was sentenced to life in prison with the possibility of parole after 30 years. The case was presented to a grand jury prior to the formal indictments. On the morning of March 27, 2024, 18-year-old Zachariah Clabo was walking to Bartow High School in Polk County, Florida, just weeks away from graduating. At the same time, Edgardo Rosado Perez had dropped off his daughter at the same school. Shortly afterward, Perez was involved in a minor collision. Instead of stopping, he fled the scene at a dangerously high speed. While speeding through a stop sign near Jackson and Pearl Streets, he struck Zachariah, who was crossing the road. The impact the boy instantly. Perez did not stop to help. He returned home to Lakeland, hid his damaged vehicle in the garage, and later left in his wife's car. Deputies tracked him down later that day and arrested him near the Brandon Mall.
If this defendant did not blow through that stop sign at 75 miles per hour, Zachariah would still be here today.
In early 2025, Perez pleaded guilty to vehicular homicide and leaving the scene of a crash involving death. During sentencing, Zachariah's grieving family spoke in court, recalling his bright personality, love for video games and skateboarding, and how he was excited for the future.
I want Zachariah to come home, but he can't because he's dead. He's dead because Eduardo killed him.
He had so much more life to live, and now he'll never do the things he loved and dreamed of doing, all thanks to you.
Zach was enjoying life like he usually does, going to school, playing video games. He was there for everybody else, skateboarding, hanging out.
The only thing I hope for is that you're used as an example for stricter punishment for reckless driving in Polk County. All I ask is that his senseless death not be in vain.
They described their heartbreak over losing him so suddenly. Perez's wife testified that he had been under stress, juggling multiple jobs, and Perez himself expressed remorse, saying he never intended to harm anyone.
I would like to apologize before the family.
No fue nada intencional, solo fue una mala decisión que tomé en mi vida.
It was not intentional, it was a bad decision that I made in my life.
Judge Michelle Pinkett sentenced him to 20 years in prison with credit for time served. Zachariah's family hopes that his death sparks changes in traffic safety enforcement so that others don't have to endure a similar loss. On March 18, 2022, Ariah Jackson was fatally shot in a drive-by attack outside her home in Pontiac, Michigan. She had just returned from school with her mother, sister, and two cousins when shots were fired from an orange Chevrolet Blazer that had pulled up near their driveway. A bullet struck Ariah. She later died at the hospital. Her mother sustained a grazing wound, while the others were physically unharmed. The shocking incident devastated the community and drew intense focus from law enforcement. Investigators quickly linked the shooting to gang activity and identified 19-year-old Justin Rouser, a known member of the 4-Block gang, as the suspected shooter. He was arrested days later in Troy, Michigan.
State of Michigan versus Justin Rouser.
As the investigation unfolded, more suspects were brought in.
Pretrial Services is asking that the defendant's bond be denied based on the nature of the offense.
Any questions from you?
No, the bond was denied.
That's correct.
Rouser was formally charged with first-degree murder and assault with intent to murder. Authorities also arrested 21-year-old Dejion Bryant, another alleged gang member, for lying to police during the inquiry. The suspected getaway driver, Jawan McDonald, surrendered on March 28, 2022, and was also charged with first-degree murder. In April 2013, 21-year-old Julia Murfeld of Muskegon, Michigan, was secretly recorded trying to hire a hitman to kill her husband, Jacob Murfeld. Unbeknownst to her, the man she thought was a contract killer was actually an undercover police officer. In chilling footage later released to the public, Julia calmly explained that her husband would be easier than divorcing him and planned to make it look like a robbery. She offered a $100 down payment and even asked that the murder not occur inside their home to avoid creating a mess. Her motive, police later revealed, was to cash in on Jacob's $400,000 life insurance policy. Julia was arrested and charged with solicitation of murder shortly after the meetings. During her sentencing in July 2013, Julia expressed remorse and took full responsibility for her actions.
Is there anything that you would like to say before sentencing?
Yes, Your Honor.
Okay, go right ahead.
I would like to start out by saying that I do not believe that I'm above punishment. I know that what I did was wrong, and I take full responsibility for it. My tears are not for your pity, Your Honor. My tears are for remorse. Excuse me. Fortunately, the two people who matter most have already forgiven me. My husband, who actually sits behind me right now, has already forgiven me. And the second is God. And honestly, they're the only two people who matter. I don't want to go to prison, obviously, who does? But if that's where God sees fit to send me through you, Your Honor, then I will take my punishment humbly and without complaint. The Lord has blessed me so much this far, I don't have anything to complain about. Honestly, it could have been worse. The crime that I attempted could have been carried out. And that alone, honestly, is the worst punishment anyone should ever have to endure, and I will endure it for the rest of my life every single day. I understand that just because I don't want to go to prison doesn't mean that I should not go. There's a passage in the Bible. It's Psalm 119, 67 and 71, and it says, "Before I was afflicted, I went astray, but now have I kept thy word. It is good for me that I have been afflicted, that I might learn thy statutes." And I completely and wholeheartedly agree with that, even if it means a little more affliction, Your Honor. I would rather be incarcerated for however long you deem, knowing that my husband is alive and well, rather than have the crime accomplished. I'm not asking for no punishment, Your Honor. I'm asking you to maybe consider my words, and if you would find it in your heart to give me a little bit of a lighter one. Thank you.
She acknowledged the seriousness of the crime and quoted scripture in an emotional plea for understanding. Her husband, Jacob, the intended victim, spoke on her behalf in court.
I would like to say, I start this off by, I wholeheartedly forgive my wife for all she has done in this act of hatred. I know that my wife is a wonderful person. She is a godly woman, even so much more so now than she ever has been. And I know that this is a crime that is on the top of the list of the most, I guess, evil, non-godly things you could probably do. But I know my wife, and I've been with her for 4 years, known her for 5, and I know that she's a godly person, and that after talking to her, she's very repentant of the sin she's committed. And before this, she's been a wonderful person, a wonderful wife. I'm sure, as you know, we have 2 young children. She's been nothing but a great mother to them. And I would just like to portray to you, Your Honor, that I don't know what kind of a godly man you are, and I won't ask, it's your opinion. But if you could look in your heart today and just have mercy upon my wife so that she may not have to be away from me and my children for a long time, because I know the young years of a child's life are the most important ones, and I'd like her to be there for every single second that she can. So I just ask in God's name that you would please show mercy as much as you can to my wife. I know she's not beyond punishment, as she stated herself, but I would just ask for a lighter sentence if you could, please, sir. That's all I have.
He described her as a loving wife, a devoted mother, and a godly woman who had strayed. Asking the judge for leniency, he said he had already forgiven her. Despite his plea, the court sentenced Julia to a prison term of 5 years and 8 months to a maximum of 20 years. In November 1998, a man named Leroy Owens was killed in Nashville, Tennessee. Witnesses said he had been attacked by 2 men in a white station wagon. Owens tried to get away, but was later caught and beaten to death. The attack was said to be over a drug-related dispute. Years later, in 2005, Joseph Webster was arrested and charged with Owens' murder. The case against him mainly relied on the testimony of Tammy Nelson. She claimed to have seen Webster commit the crime. However, Nelson was struggling with drug addiction at the time, and later admitted she had lied. She confessed she hadn't seen the murder at all. Despite this, Webster was found guilty in 2006 and sentenced to life in prison. While behind bars, Webster never stopped claiming he was innocent. In 2016, he hired attorney Daniel Horwitz, who began digging deeper into the case. With help from the Innocence Project, they had the cinder block tested for DNA. The test showed male DNA, but it didn't match Webster's. More problems with the case began to surface. Several eyewitnesses had never been contacted during the original trial. These witnesses described the killers in a way that didn't match Webster. One detail stood out. No one mentioned that the attacker had gold teeth, something Webster clearly had at the time. On top of that, members of the victim's own family said that another relative had confessed to the crime. The white station wagon used in the murder also belonged to that same relative. Webster's case became the first to be reviewed by the Davidson County District Attorney's New Conviction Review Unit, CRU, which was created in 2016. At first, the CRU rejected his appeal, saying the new evidence didn't clearly point to someone else. But in 2019, after changes were made to how the unit worked, they agreed to take another look.
It's never seen that registration, which is in the filing. There are 2 additional pieces of new evidence that were developed to the effect that both the victim's bloody shirt, which we had agreed would be tested, but then found out had been destroyed prior to Mr. Webster's indictment, and the 911 calls that were made by eyewitnesses during this murder had both been destroyed prior to Mr. Webster's indictment. And in terms of fault for investigating, Your Honor, it's very clear, and I think the parties are in agreement here, that Mr. Webster was deprived of any information related even to the identity of Mr. Boyce and Mr. Henderson as a consequence of the fact the trial counsel withheld the file from him and from post-conviction counsel and from me until the latter half of 2018. Now, that is just Mr. Webster's portion of this investigation. The state has conducted its own investigation in this matter in parallel. I am aware of parts of it. Other parts have been redacted, and I expect that there are additional pieces of it of which I am not aware as a result of a pending investigation or perhaps investigations related to this homicide and others. So the answer to your question, Your Honor, fairly circuitously, is that none of the new evidence being presented here today was presented at trial, was presented in post-conviction proceedings, was presented in the coram nobis proceeding, was presented in the pro se petition for DNA testing either. This is all new, and that's why it's appropriately before the court, both with respect to the witness testimony and the new scientific and DNA evidence.
But, and I'm generalizing here, but that, and again, I hear from the state, but that issue about the second or another individual being the perpetrator in this offense was factored in to the state's review.
That issue, certainly. Ms. Norman's testimony, definitely not.
This time, they concluded that the case against Webster was too weak.
I would ask the state to view the investigation by the state and our position in the same manner that we might view persuasive versus controlling authority. Although we did address within our report and our filing some of the issues that Your Honor mentioned, we went further. There were corroborating information that we gathered from witnesses that was not available to Mr. Webster at the time of trial. So although we certainly reference some of the testimony, there is far more support for that testimony that we've uncovered post-trial that the court did not hear, that was not available to Mr. Webster, that perhaps could have changed or given different consideration to the credibility of some of those witnesses. The state has spent hundreds of hours and several years on this investigation. We are not blind to the weight of disturbing the decision of a jury, and would not be asking the court to disturb that decision if we had not lost confidence in this conviction. And sir, at this point, the state has fully lost confidence in the conviction of Mr. Webster, and we believe that vacation of the conviction is the appropriate remedy.
And I may be using Mr. Horwitz's words, he's better at words than I am, but I'm using those to ask you a question. Is the state convinced that another individual committed this murder?
Your Honor, I am hesitant to comment on an investigation that is ongoing. I do think that our report...
It's not Mr. Webster.
We are, sir.
And you're determining, and I don't want to reveal anything that you don't want to reveal, but you're determining whether, I guess I'm kind of asking this, and maybe y'all met with the Owens family, that's great, but asking this for them and me, but that person may be charged.
Sir, it is our intention to do everything within our power to see that the Owens family sees justice.
Okay. Anything further?
No, sir.
Anything further, Mr. Horwitz?
Just extremely briefly, Your Honor, I do just want to call this court's attention to the fact that the post-conviction DNA testing statute calls for a hearing regardless of any time bar whatsoever if post-conviction DNA analysis is favorable to the petitioner. Again, I think the parties agree that the DNA analysis that was conducted here was favorable. There may be some dispute as to whether it is dispositive.
The weight of what a jury would give it.
But it is nonetheless favorable, and that alone brings this matter within the court's jurisdiction and appropriate for hearing.
And my only final thought, Your Honor, is that we would like to incorporate our report as an exhibit.
The report from your review?
The individually filed report that we submitted.
Okay, I think you did. I think you made it, didn't you, Mr. Horwitz, a copy?
I did.
Yeah. Or a redacted version. Okay, it's already in the filing. Okay, I mean, I appreciate the party's feedback in terms of my inquiry, because I've been around, nowadays the younger people say a minute, 23 years and 30 plus counting around this building or this buildings like this. So it is unique. That's why I was trying to gather, not in any way implying what should be done or shouldn't be done by my questioning. I'm just trying to get clear on where we are procedurally and what this court, from the attorney's perspective, is to be looking at. So, as I mentioned, it is a unique set of circumstances weighing, as the state mentioned, the jury process that happened, 14 years ago or so, 14 and a half, versus an innocent person that nobody would want incarcerated if, in fact, that is true. So, let me take this under advisement, issue an order. It doesn't have to, y'all submitted the issues here in court and in your filings fairly and competently, obviously, and I'll get that order out hopefully within a few days and get, you'll do whatever you need to do for purposes of appeal if it has to be, or if it's granted, then y'all work out what logistics need to happen.
Thank you.
All right, you can step back, Mr. Webster.
The judge agreed. On November 10th, 2020, Joseph Webster's conviction was officially thrown out, and he walked free after nearly 15 years in prison. After his release, Webster said he wanted to rebuild his life and spend time with his family. His lawyer started a fundraiser to help him start a trucking business and adjust to life outside prison. On March 18, 2025, Mahendra Patel, a 57-year-old retired engineer, went to a Walmart in Ackworth, Georgia, to buy Tylenol for his elderly mother. While in the pharmacy aisle, he approached a woman, Carolyn Miller, who was using a motorized cart and was accompanied by her son and his sibling. Patel asked her for help locating the medication. Miller later told police that Patel reached for her son, claiming there was a 10-second tug of war. However, surveillance footage showed a brief interaction where Patel leaned slightly toward the boy, then backed away and kept his hands in his pockets. He continued shopping and later brought back the Tylenol. The footage also showed Miller calmly interacting with Patel after the incident, even giving him a thumbs up. She did not immediately report the event to store staff and waited around 30 minutes before calling the police. Patel remained in the store for about 10 minutes, made a purchase using his debit card, spoke with employees, and did not attempt to leave quickly. He voluntarily spoke with law enforcement 3 days later when contacted. He explained that he thought Miller might be disabled and had tried to help her point toward the medicine.
Judge, we are here because the state has accused Mahendra Patel, and he goes by Mick, but Mick Patel, of, at first it was kidnapping, and then it moved to attempted kidnapping. So he was arrested on March 21st of 2025 for an incident that allegedly happened at a local Walmart on March 18th. The officer took out a warrant for kidnapping, not attempted, assault, and battery. Subsequently, the state indicted that case on April 3rd. We had a bond and probable cause hearing scheduled for April 16th, but when the state indicted it, they indicted it for attempted kidnapping and then misdemeanor assault and misdemeanor bond. So we were not able to have that bond hearing. Mr. Patel was not given bond at first appearance. At that time, he was charged with kidnapping of a minor. The state essentially is alleging that Mr. Patel had an interaction with a lady named Caroline Miller at this local Walmart. They've said that Ms. Miller was pointing out to Mr. Patel where the Tylenol was in the store, and that Mr. Patel grabbed the child and started pulling the child away from Ms. Miller. Ms. Miller has said that they engaged in a back and forth and a tug of war, as she described it, for 10 seconds before she was able to finally get the child back.
Initially charged with kidnapping, Patel was later indicted for attempted kidnapping and misdemeanor assault. During a bond hearing in May, his attorney, Ashley Merchant, argued that the surveillance footage showed no abduction attempt.
Evidence that he would come to court, that he is not a flight risk. Of course, I haven't seen the video, right? So I don't know what it's going to show me, but I'll let you do that. And just so everybody knows, I have my own monitor down here. I'm not staring at the floor. So
wonderful.
I'll let you do that.
Thank you so much. All right, and this is the compilation. So the reason that we did this part is to kind of show the timeline. You can go ahead and play it. The timeline for the court when Mr. Patel enters the store at 8:16. And then you can see him walking, and he's on his phone, texting his daughter, which can be corroborated by the phone when we get it. Now you see him, he's walking to the pharmacy section. This is the pharmacy section. And now this is when he actually interacts for the first time with Miss Miller. So that's Miss Miller in the cart, in the scooter. The first time that they've met, and they're talking about the Tylenol. And so the gentleman, you can see a gentleman in an orange shirt behind them. That's the gentleman I was talking about. That's the witness. His name is Mr. Leva.
All right.
He's the one that later assists.
All right.
And witnessed the whole thing. So this is the other view, so you can see how close Mr. Leva is. And behind this display cart is that's when you can see the beginning of Miss Miller's cart. So the alleged incident is happening now. Here's the other view of it, flipping back so you can see both views. That's the alleged incident right there. Then she points. He moves on, goes to get the Tylenol. She backs up into the display cart. She's laughing, joking with this gentleman. This is literally a split second after this alleged kidnapping. You see her child kind of get off the cart. She runs over the child's foot. The guy jumps in to help. She was having trouble with the cart. I mean, everybody says that. All of this is after this alleged kidnapping has taken place. There's Mr. Patel entering the video again. You see him walking past. He talks with this guy that's witnessed this alleged kidnapping. Miss Miller's right there, doesn't say a word. She's puttering along in her cart. He's chatting with this gentleman, asking about the Tylenol. This gentleman speaks Spanish, so the communication's a little bit difficult there. Mr. Patel goes to try and find a Walmart employee. He walks past Miss Miller again. There's that other interaction I mentioned, the third interaction, walks past her to find a Walmart employee. Again, this is all after this alleged kidnapping, so, he's not fleeing. Want to find another employee. There's the employee walking him back to the Walmart pharmacy to show him where the Tylenol is. So you can see Miss Miller puttering along in her cart in the back of this video. This employee shows Mr. Patel where the Tylenol is. Miss Miller puttering along still on her cart. Mr. Patel walks past her, shows her, look, I got the Tylenol. She gives him a thumbs up. He keeps going. That's when, at 8:27, that's when she first told this Walmart employee about this. At the same exact time, Mr. Patel is paying for his Tylenol, so he's still in the store. And you can see if you zoom in, and we didn't do that, but it's the rapid release Tylenol. It's a special gel Tylenol that it's the exact same label that his daughter texted him a picture of to buy.
Eyewitness accounts, including a shopper and Walmart employee, confirmed there was no attempted abduction. Both witnesses said they saw nothing alarming and would have intervened if necessary.
There's two alleged witnesses, the Walmart employee and Mr. Leyva. Mr. Leyva is mentioned on the warrant. Both of them, we have interviewed them. Both of them had said if they had seen a kidnapping, an assault, an attempt, anything like that, they would have stepped in, that they were there, didn't see it. They all confirmed the Walmart was busy. There were lots of people around. The Walmart employee said that Mr. Patel was a friendly older gentleman, was very friendly with her, kind of gave her like a hug almost, like she was so happy when she finally helped him find the Tylenol. She said that she didn't know what was going on with Miss Miller, but she's not permitted to ask what her handicap is, but she said it was suspicious that she didn't scream, call 911, anything like that. And then Mr. Leyva, the gentleman in the orange shirt that you saw, again, he said that Mr. Patel lifted the child like the child's father, and that Miss Miller sort of pulled back the child. There was no tug of war. Mr. Leyva actually was mistaken and thought it was the younger child that all this was happening with. He was kind of confused, but the one thing he was sure about was that there was no attempted abduction, and had he seen anything like that, he was close enough that he would have stepped in and done something. He also told us that there were lots of people that witnessed the interaction. He speaks Spanish, so we had a Spanish interpreter interview him because there was definitely a language barrier with him, though. Mr. Patel talked to the police. He answered the police's questions. He told the police that he leaned in to pick the child up so that she could show him where the Tylenol is. He told them that.
Where was this?
At the police station when he was arrested. So he was arrested on March 21st. So before, they didn't talk to Mr. Patel. The police got the warrant for kidnapping. They arrested Mr. Patel on March 21st. They took him to the police department and interviewed him. When they interviewed him, and the state has not provided us a copy of this, but this is based on pleadings and Mr. Patel, what transpired there. He said that he did. I mean, he confirmed that he leaned in to pick the child up so that she could stand up and show him where the Tylenol was. At that point, he believes, as anyone would, that she's handicapped. And she's got two young children, which you can clearly see she's having some trouble with the cart. It's a reasonable thing. And if you think that there's a child that's falling or might fall and someone's trying to stand up to help you, the reasonable thing would be to help that person. The state in one of their pleadings pointed out that he did not tell the police specifically that he thought the child was falling, but nobody asked him that either. He also said that they didn't ask him if he told Miller immediately that he was trying to help her. But what he explained was that Miller didn't want his help. As soon as he realized that, he stopped, put his hands back in his pocket, and moved on. So we're talking a few seconds here, and he's trying to help. She says she doesn't want his help. He pulls back. You can see it, and you can see it on the video.
Patel's background was also discussed. In 2006, he faced a white-collar case for which he took full responsibility, cooperated with authorities, repaid all restitution, including his co-defendant's share, and earned early release from probation. He had a 2020 reckless driving conviction, which also ended with early probation termination. A pending DUI case from 2005 was mentioned, but his attorney noted he had followed all bond conditions. More than 46,000 people signed petitions supporting his release. The prosecution, meanwhile, argued Patel had admitted to upsetting the mother and grabbing the boy, and expressed concern over his behavior and financial resources. They noted he had attempted to walk away from authorities during his initial contact and requested a high cash bond with conditions.
I don't look at anything on social media, but I must say that it's impossible to not see that it's out there, and it's been very difficult to not look at anything, but I've done my very best. So I feel like I'm going into this on an even keel with the state and the defense. I'm going to grant this man a bond. He's entitled to a bond based upon even the allegations of the state. His history here, he owns property, you said, in the Harrison district. He's educated, he's retired, manages properties, plural, apparently. He's married, he's in the Kiwanis Club. I mean, if he's got all that he needs to show me that he's a member of our community and that he has ties to the community. I don't blame the state from pointing out, and you did it yourself, Ms. Merchant, that he has some convictions. He doesn't have any type of conviction that bothers me in terms of any type of violent behavior or anything of that nature. I don't see any arrest, haven't heard any evidence of any arrests for any type of sexual, certainly child sexual type arrests. I'm not worried about that. I don't believe he poses a risk to the community. The evidence from the video, and I won't comment on what I think the video really shows as far as guilt or innocence. It's not my job today. But the facts do show me that he hung around, and I don't find that he's a flight risk based upon what I saw in the video and what was just, I'll receive it as a proffer from counsel about him hanging around. I'm not concerned that the police didn't get him the same day because he's presumed innocent, and innocent people don't worry about the police coming to get him. So that didn't bother me. I'll grant a $10,000 bond. That was the number you gave me.
Thank you, Judge.
I don't have any problem with it. He can make it any way he wants. It doesn't have to be a cash bond.
Judge Gregory Poole ultimately granted Patel a $10,000 bond with GPS monitoring and ordered no contact with witnesses. After spending 49 days in custody, Patel was released as the case continues through the legal system. On the night of December 14th, 2019, Alexander Del Toro Jr. was celebrating his 28th birthday with his parents in Margate, Florida. What began as a family occasion ended in tragedy. After leaving the celebration, a heated argument broke out between Del Toro and his father while they were driving home. According to police, Del Toro struck his father. However, during the trial, the defense argued this contact was accidental, claiming it happened while Del Toro was trying to maneuver the vehicle, not out of aggression. The situation escalated once they arrived home. Del Toro testified that his father pushed him up against a concrete wall during the argument, which made him fear for his life and for his mother's safety. He said he believed his father might be armed. In response, Del Toro drew his legally owned firearm. As he raised it, his father allegedly hit the weapon, causing it to discharge. The bullet struck and killed his mother, Cindy Del Toro. Authorities charged Del Toro with manslaughter, battery, and carrying a concealed weapon. He was taken into custody the following following day and later released on a $40,000 bond, Del Toro filed a stand your ground motion, claiming he acted in self-defense. That motion was denied, setting the stage for a trial in May 2025, over 5 years after the incident.
And you're going to hear that back in December 14th of 2019, Cindy went out with her mother, her husband, and her son to celebrate her son's birthday. You're going to hear that on that night, they went out for dinner, they got ice cream, they looked at Christmas lights, they dropped off her mother, and then they headed back to their home. This was just like any other night for Cindy, until it wasn't. That's why we're here. This was Cindy's last night. And you're going to learn that the person responsible for ending Cindy's life was Alexander Del Toro Jr., Cindy's son. Now, how? How did this happen? You're going to hear that on that night, Mr. Del Toro Jr. knew that he had a loaded firearm. This was his firearm that he carried. And he took that loaded firearm, he took it out of its holster, he carried it, he put his finger on a trigger, and a bullet from that firearm ended up in the middle of Cindy's face. She had passed away at that point within minutes, if not seconds, right outside of her home. And throughout the evidence in this case, you're going to hear from the defendant's words different versions of what he said happened. You're going to hear the statement that he gave law enforcement on that night. And on that night, he says, he went out, it was his birthday, they get home, he gets into a verbal argument with his father, he throws a water bottle at him, his father has him pinned up against the wall, at which point the firearm in his holster is pinching him, so he takes it out and tosses it, and states that's when it went off, and hit his mother in the middle of her face. But you're going to learn through the evidence that in order for that firearm to go off, his finger had to have been on the trigger. And you're going to hear that that firearm was operable, all safeties were in place, and it was working just as it should have. But you're also going to hear another version, another story that the defendant has of that night. This one came years later. This version starts the same way. The family went out for his birthday. They get home. He gets into a verbal argument with his father. He throws a water bottle at him. And then that's when some shoving happens. During that shoving, his glasses fall off of his face. He can no longer see. And he says that even though he could not see, somehow he knew that his dad grabbed something out of his pocket. And he assumed, he guessed, that what his father took out of his pocket was another firearm. But the evidence in this case is going to show you that there was only one firearm. The firearm that in both of these versions, Mr. Del Toro Jr. says is his, and the firearm that the bullet came out of that struck his mother in her face. In this version, you're going to hear that when he thinks his dad took something out of his pocket that he thinks was a firearm, it could have been, that at that point he takes out his loaded firearm that he knows is loaded, and he puts his finger on the trigger and he points it at his dad. He says at that time, even though he says that his dad had a firearm, he said his dad comes up to him and smacks his firearm. And when he did that, the firearm went off, a bullet came out, and it struck his mother in the middle of her face. Ladies and gentlemen, you're going to hear that the common denominator in both of these versions, both of these stories that Mr. Del Toro Jr. tells, is that he had a loaded firearm that he knew was loaded. He carried that firearm. He took it out. He had his finger on the trigger. And because of that, Cindy Del Toro is no longer here. And we spoke about this in jury selection. The judge actually read you an instruction about how everyone has a duty to act reasonably towards each other. And how in this great country that we all live in, there are laws and rules that we all need to follow. There are laws and rules that we all share. And those are put in place to prevent innocent people from being killed based on the irresponsible actions of somebody else. you're going to learn all about those irresponsible actions of the defendant taking out that firearm, putting his finger on the trigger, and ending Cindy Del Toro's life. Now, I know some people might think maybe it was an accident. He didn't mean to do something. But the evidence is going to show you that this is not an accident. It is not an accident to carry a firearm that is loaded, take it out, put your finger on the trigger. In carrying a firearm, everyone who does that has the responsibility to act responsibly with that firearm. And because of that, and because of those choices that Mr. Del Toro made, Cindy is no longer here.
During the trial, Del Toro testified in his own defense, demonstrating how the weapon allegedly fired when his father hit it. He insisted he did not mean to shoot his mother and described the moment as a tragic accident. His legal team argued that his actions were driven by fear during a chaotic and emotional confrontation. The prosecution, on the other hand, questioned his version of events and pointed out the lack of evidence showing that his father had a weapon. After about 4 hours and 13 minutes of deliberation, the jury returned with its verdict: not guilty on all counts.
Go ahead. Publish the verdict. In the Circuit Court of the 7th Judicial Circuit in and for Broward County, Florida, State of Florida, plaintiff versus Alexander Del Toro Jr., defendant, case number 19-014728, CF10A, Judge Lorena Mastroigo. Verdict: count 1, we the jury find as follows as to the defendant, Alexander Del Toro Jr. In this case, the defendant is not guilty. So say we all this 6th day of May, 2025 at Fort Lauderdale, Broward County, Florida. Okay, does either side would like the jury poll?
Yes, Your Honor.
Okay. If you can poll the jury. Castano, is this your true verdict?
Ladies and gentlemen, at this time I want to thank you for your time and consideration. I also want to wish to advise you of some very special privileges you now hold as jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury deliberation, discussions, and votes should remain their private affair as long as they wish. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror.
The courtroom was stunned. Del Toro had rejected a plea deal earlier in the case that would have resulted in a 10-year sentence, a decision that many had criticized. But his gamble paid off. The jury clearly believed his account of what happened. For Del Toro, the acquittal brought a legal resolution, though the emotional weight of his mother's death will remain. His defense attorney expressed hope that he could now begin to grieve and move forward. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.